Well, good evening, everyone. Glad to see you all here in person. It's been almost 3 years. I was out with my wife a couple of nights ago at a restaurant that we hadn't been to in 3 years, and the waiter asked us, "Well, when's the last time you were here?" And I said, "Well, pre-pandemic. That's the way we measure time now, right? Pre-pandemic, post-pandemic." So I haven't been in this room since before the pandemic, and so it's really wonderful to see all of you here today to talk about a very interesting and important topic that, quite frankly, doesn't get the publicity that a lot of the other HOA topics receive. And that is, how can disputes in homeowner associations in Arizona be adjudicated without having to spend a lot of money on a guy like me? Now, in Arizona, there are basically, three ways to resolve differences with your homeowners association on a legal level. You can always, if you have a difference with your association or you have a difference with your board of directors, you can always try to address that difference with your actual board of directors by attending a board meeting or attending an annual meeting, maybe reaching out to your association's property manager and setting up an appointment. So, minor issues or minor disagreements can be handled on what I would call the ground level or the grassroots level. And hopefully the vast majority of disputes can be handled that way. So I always suggest when I'm walking in the mall and someone approaches me or they give me a call, I always say, have you had an opportunity to have a discussion with your board of directors at a board meeting? Again, the vast majority of these issues can be handled there. But unfortunately, not all issues can be handled at that grassroots or ground level. So in Arizona, there are three basic ways that we can escalate the resolution of conflicts between homeowner associations and members. And the first way is a non-judicial way. You can seek mediation or arbitration. And you can seek, there are several organizations here that can aid you with that. The one that comes to mind is the Community Associations Institute, or CAI. They have a mediation program that you can participate in. Now, mediation is an opportunity that both parties must agree to participate in. So it's not a forced type of scenario, but it is an initial opportunity to, again, avoid a guy like me and have an arbiter or someone who is neutral to the problem address the problem. Sir, you had a question in the back? No. Okay. So we want to start with a meeting with our board of directors or our management or our community association manager to try to resolve as many issues as we can. If we can't do that, then, mediation is always a good idea because it keeps the conflict at a low level. Sometimes, however, we have to escalate the conflict, and there are two ways in Arizona to escalate the conflict. The first way is to file a lawsuit in Superior Court. Now, if you file a lawsuit in Superior Court, you're going to have to hire a guy like me, and you'll go through the legal process as is listed out in our judicial system here in Arizona. That can be very expensive, especially if you hire, someone who has a very high hourly rate. The second way, which is what we are going to talk about today, and which is our focus for today, is to use the conflict resolution procedures that are offered through the Arizona Department of Real Estate that could eventually end up in a hearing before the Arizona Office of Administrative Hearings. Okay, so a couple of terms that we're going to that will be used throughout the presentation that you will want to be familiar with. So the first term is going to be AZDRE, which stands for the Arizona Department of Real Estate. Okay, the second term is OAH, which stands for the Office of Administrative Hearings. Okay. Now, the Arizona Department of Real Estate is an extension of the executive branch here in Arizona. So that is an executive function in Arizona. Now, the Office of Administrative Hearings is a quasi-judicial branch. It's an administrative law branch. And Greg will talk much more about that. That's within his purview. So he'll talk more about how the Office of Administrative Hearings operates and how it is different from Superior Court. Now, again, we will get into this third process, this process that you can avail yourself of without having to hire an attorney. You can represent yourselves in these processes. Now, you don't have to, but the process is built to allow individuals to have the opportunity to discuss conflicts in a quasi-judicial fashion without having the need to bring in an attorney. Moreover, if your opponent has an attorney in this process, you will not be subject to attorney's fees if you do not prevail in your petition. In the Superior Court, if you bring a lawsuit in the Superior Court and you do not prevail, there is the opportunity for the judge to award attorney's fees against you in Superior Court. That is not available in the Arizona Department of Real Estate procedures. Okay, so with that, I'm going to bring Greg up, and I would have to sit here for hours to explain Greg's all of his accomplishments and achievements. So I'm going to let him do it, so I don't leave anything out. Greg, if you'd like to come up, tell the audience a little bit about yourself, and we will move into some of the more particular aspects of the OAH, Arizona Department of Real Estate procedures. Sure. It depends on what procedures you use. Mediation is not the same as arbitration. Arbitration usually always has a cost because you have to pay for the arbitrator, okay? Some mediation services in the Valley are free, some have a cost. It just depends on the mediation service that you are going to use. Okay, Greg? Awesome.
Bend this microphone down a little bit. One thing you'll notice about me is that I'm probably the shortest person who's ever served as a director for a state agency in Arizona, and perhaps the baldest. Thank goodness I'm set off by my friend Augustus here. Folks, my name is Greg Hanchett, and I am the acting director of the Arizona Office of Administrative Hearings. I've been in that position for about 8 years now. And what I'd like to do is start off first talking a little bit about my background in administrative law, and then talk a little bit about the Office of Administrative Hearings position in the state agencies. And we're kind of unique. And I'll get to that in a minute, because we have unlike many agencies, like who here is familiar with the Arizona Department of Health Services, right? Raise your hands. Everybody knows that. You know how many different things those guys do? It's off the charts, infinite number of different agencies and developments and things like that. We do one thing at the Office of Administrative Hearings. Basically, we provide due process hearings, and don't get shook by that little term due process. It just means a hearing that allows every party in the proceeding to get to say their side, and then present evidence on their side and argue about their position, and then have an administrative law judge make a decision. I'll get into that a little bit more, but a little bit about me. I have been an attorney for longer than I care to admit now. I think I'm pushing 37 years. I spent about the first 10 years of my life as a prosecutor of the city of Phoenix. And in 1999, I became an administrative law judge with the Arizona Office of Administrative Hearings. Was there for 2 years, and I got recruited by the state of Montana. Went up there and was there for 12 years. Working as an administrative law judge and in a bunch of different areas. And we'll talk about all the areas that the Office of Administrative Hearings does, just as a way of background in a minute. And then in 2015, I came back down here ostensibly to go to work for the Industrial Commission of Arizona, and got appointed by Governor Ducey to be the head of the Office of Administrative Hearings. So what does the Office of Administrative Hearings do? As I indicated, we provide a forum for people to have their hearings heard in an independent state agency. And I'll just read you our mission statement real quickly here. The mission statement of the Office of Administrative Hearings. And by the way, I'll give you information at the end of this. There's actually links in this PowerPoint for live links to resources, including the website of the Arizona Office of Administrative Hearings. So if you get bored one evening, you want to go look at it, you can jump in there and take a look at it. Mission statement of the Arizona Office of Administrative Hearings is that we will contribute to the quality of life in the state of Arizona by fairly and impartially hearing the contested matters of our fellow citizens arising out of state regulation. We do a number of agencies. We actually cover 52 different agencies. We have 7 administrative law judges, not including myself. I'm the chief administrative law judge, but I don't sit in hearings. I get to do the boring, mundane administrative stuff. Doesn't mean that I'm not aware of the areas of law, but I don't get to adjudicate them anymore, except if we get pinched for people. I do really exciting tax cases where you have to have toothpicks to keep your eyes open, but that's a different story. Just to give you an idea of the different areas that we cover, we go from very small, for example, Arizona health cost care containment cases about eligibility for medical services for people who are indigent, all the way up to highly complicated regulatory matters involving water quality, air quality, mining permits, and things like that. We cover the whole gamut. We are part of a group of entities known as central panel agencies. And what's nice about having a central panel agency is that the Arizona Office of Administrative Hearings, when it makes a decision, is beholden to no state agency for its decision. OAH's sole concern is to ensure that every party who's come into that hearing has had an opportunity to have their case heard and to ensure that the facts are correctly decided and the law is applied as it should be. We don't always get that right. That's why there's appeal methods, which we'll talk about later, but that's what we strive for, okay? So what I want to do tonight is talk a little bit about the HOA process and to kind of springboard off of what Augustus said. One of the nice things about having a hearing come to the Office of Administrative Hearings is that it is a very simplified procedure. We actually have 12 statutes and 20 administrative rules that apply to us. 3 of those apply for appeal. So actually about 15 or 18 rules that deal with procedure. It's pretty easy to comprehend. You can sit down in a couple hours, go through it and understand it probably as well as any attorney can. OA strives to make it a very open forum. You know, we have certain technicalities, as it were, that we have to follow because we have statutes we have to follow. We have rules we have to follow. But beyond that, we try to ensure that everybody gets their opportunity to be heard. One of the nice things about administrative adjudication of HOAs, and I'm not knocking Superior Court adjudication of it, although as Augustus said, it's very costly just from having lawyers on board. But one of the nice things about HOA is that, for example, the rules of evidence that would otherwise apply in proceedings in Superior Court don't apply here. So it's a lot easier to get your evidence in. Usually it's not a problem, you know, in terms of like, there's things like authenticating documents and things like that that are pertinent. Not hard to get that done, get those in. Typically, there's no dispute about those. They come into evidence. Not nearly the hurdles that you would otherwise experience in Superior Court. The HOA's process itself is fairly constrained, as it were. It's limited to basically these substantive statutes, these procedural statutes, and I'll explain to you basically what, and then procedural rules. So substantive means the law that controls parties' rights. That's called a substantive statute, okay? For example, HOAs can't do certain things with respect to counting votes and things like that. That's a substantive law. Procedural law is, well, once I'm in the court, how does this work? Who goes first? Who gets to make an argument? What is a judge supposed to do? Those are procedural matters. So there's not a lot of procedural matters. There's not a lot of procedural rules. As I said, by the way, and we'll go through these resources at the end of the presentation, but ARS refers to Arizona Revised Statutes. And by the way, if you hear something from this lawyer's mouth that you don't get, yell at me and say, stop, time out. What are you talking about? Because I want to make sure you understand what I'm saying. But that's Arizona Revised Statutes is what ARS is. AAC is shorthand for Arizona Administrative Code. And if there's a way to get this to folks, and I guess I'm looking for Bruce, but electronically, there's live links in this that would take you to those resources. It'd be a lot easier to do. So maybe Ross will hear me about that. I think I talked to him about it. So, all right. So let's see. We can just go forward on this, I presume. Okay. All right. So let's start off talking about the hearing process at the Office of Administrative Hearings. And I guess I should qualify this a little bit too. Augustus, I don't know if you're going to talk at all about what goes on initially at the Department of Real Estate. There's a complaint filing process, and there's an opportunity for the entity who's being complained against, because as you may or may not know, HOAs actually can bring complaints against homeowners too for certain violations, as well as homeowners bring complaints against HOAs. But there's a process that folks go through at the Department of Real Estate. And Gus will explain a little more in depth, but I want you to understand one thing, that if you, for example, are a homeowner and you're going to file a complaint, you want to make sure that you file that complaint with everything that you think is pertinent, okay? Because that complaint controls what's called the notice of hearing, and we'll talk about that a little bit later on. That notice of hearing kind of circumscribes, all right, contains, if you will, how the hearing is going to go at the Office of Administrative Hearings. The administrative law judges, I guess there's an old saying that it's not, and it's true. Administrative law judges, unlike Superior Court judicial judges, have only those powers that are given to them specifically by rule or statute. So when you get to that hearing at the Office of Administrative Hearings, you want to make sure that complaint has everything in it that you wanted to talk about. Because if it doesn't, the administrative law judge is not going to have what they call jurisdiction to adjudicate that issue. So better to be more broad, as it were, and then narrow it down. In fact, the judge might look for the parties to narrow it down to really get down to the meat of the case. But so you're going to want to be aware of that. Okay. So I'm going to go through first the trial process itself. And it really is, you know, it's really like a trial in the sense that what do we understand a trial to be, right? There's opening statements there. Whoever has watched Perry Mason or any of them law shows, you know, I avoid them like the plague because I deal with it every day. But there's an opening statement from the parties. And there's a procedure for doing that, okay? And the party with the burden of proof can make an opening statement, and I'll explain burden of proof to you in a minute. Don't worry about that. I'll tell you what that is. And then after that, other parties may make an opening statement in the sequence determined by the ALJ. And I got Ross's picture over the last part of that, but that's okay. Make an opening Ross sequence determined by the ALJ. Anyways, so you make an opening statement, and basically you're going to be told by the judge, you know, this isn't a time to give me evidence. This is a time to just tell me, give me kind of a roadmap of what you think this case is going to show. And then that'll give the judge a better idea as to which way it's going to cut and how things are going to go. All right. So this thing about burden of proof, right? Oh, and by the way, the judges, because it is an administrative proceeding, the judges have a little more, a greater responsibility, as it were, to explain the proceeding. All right. So if you're a pro se there, which is our legal mumbo jumbo in Arizona for somebody who's not represented by an attorney, judge is going to clearly explain to you how the proceeding is going to go, who has the burden of proof, who's going to talk first, who's going to put on evidence first, you know, who's going to put on evidence second, and how the closing statements are going to go. Okay. It'll be laid out for you. Be prepared for it, but it will be laid out for you. So burden of proof. Burden of proof is kind of a misnomer, but without getting too much into the weeds on it. Basically, the question is, okay, who in this proceeding has to persuade the judge that they are right? That's a good way to look at burden of proof. If we got a little more nuance, there's a distinction between burden of proof and burden of persuasion, but we're really talking about burden of persuasion in this case. Again, who has to prove to the judge what's going on? Who has the initial responsibility, as it were, to prove their case? Okay, the answer to that pretty straightforward in HOA cases. Whoever's bringing the complaint, they have to prove up, at least initially, they have to prove that there was, you know, and I'll just use an example. Okay, if it's a homeowner against an HOA, they have some obligation to prove that there was some violation of say a bylaw or a CCNR that violate, or some violation of a state statute. And that's what that is, burden of proof. There's some more discussions down here about a party asserting an affirmative defense. By the way, I have to put a qualifier on this. This is actually the same presentation we gave to the state bar, a group of attorneys. And that's why I said, there's nomenclature in here that you may not understand. I don't expect you to understand, or you may understand it better than I do, frankly. I know I've seen a lot of homeowners do better litigation than lawyers in a lot of different cases. Not necessarily HOA, but a lot of other cases. So, you know, let me know. But so I'm not going to worry about asserting affirmative defense. That's kind of a legal question. So there's this other thing is how much evidence do you, by the way, I tend to walk away from microphones, and I realize I'm not supposed to do that in virtual meetings, but I tend to do that. I like to wander around and I gesticulate because I have some Italian blood in me somewhere. Anyways, yeah. So what's the standard of proof? Again, this is more of a legal concept, but I think it's important to understand it. It's what's called a preponderance of the evidence, okay? And who here's ever served on a jury? Any of you served on a civil jury? You served on a civil jury? The other folks raise their hand, been on a criminal jury? So remember the lawyers up there explaining to you what's the burden of proof. In a criminal case, it's beyond a reasonable doubt. So that's kind of if you think of the scales of justice, that's kind of a lot heavier, right? Well, in a civil case, and I'll say that for the most part in OA cases, this is true. There's some exceptions, but it is true in HOA cases. The burden of proof is what they call a preponderance of the evidence. So if you can imagine the old gold scales, right? The scales of justice, as it were, two plates, right? And you put a metal on one side, and then you put known weight quantities on the other till they balanced out. So what you want to have for preponderance of evidence, if you can see it, is that the evidence that you presented slightly tips in your favor and persuades the judge that your position is correct. That's preponderance of the evidence. It's not nearly what it would be in a criminal case, thankfully. I'm sure Augustus thinks that too. So it's not a hard burden to meet, but it is a burden. And you do have to persuade the judge by a preponderance of the evidence that your position, whatever it is, whether you're an HOA bringing a complaint against a homeowner or homeowner bringing a complaint against an HOA, that your position is correct. Okay. Any questions about that? Clear as mud. Yes, ma'am. I don't have one with me, but I may make the suggestion. Perhaps he can. Augustus might be able to, but also on the Office of Administrative Hearings website, we have all of our cases, all the judges' decisions, including well, not all of them, the ones that aren't confidential, but HOA cases are not confidential cases in Arizona. They're open to the public. So you can go on that website and you can take a look at different cases and see what kind of evidence was presented. All right. The next thing about the hearing process itself is what's called the order of presentation of proof. Basically, it's who gets to go first, right? And the answer is always whoever has the burden of proof gets to go forward first and put on their evidence. And the administrative law judge determines if the administrative law judge determines that requiring another party to proceed first would be more expeditious or appropriate, they can do that as long as it wouldn't prejudice any other party. So what am I talking about? Typically, and in an HOA case, this is almost always going to be true. The party with the burden of proof, again, let's use the example of a homeowner against a homeowners association. They are going to have to put their evidence on first. And then the other side would have an opportunity to cross-examine, ask questions of those witnesses. And then once they were done with their case, the respondent, HOA, would put on its evidence. The homeowner complainant would have the opportunity to ask questions of that person. And then if there wasn't something called rebuttal, which there could be, and we'll talk about that a little bit later on too, it'll go to closing hearing. So that's kind of the gist of that, who gets to go forward first. That's not always true. Some of the cases that the Office of Administrative Hearings does, it's more efficacious, as it were, for the judge to, and it typically involves when an agency is going against an individual, the judge might require the agency to put on its evidence first. That doesn't mean that the judge fails to understand what burden of proof is. The judge does, but it's just more efficient to do that. I'm not aware of that having happened in an HOA case. It doesn't mean that it couldn't. It could be a situation where the judge might say, hey, we're going to let the other side put on their evidence first. I completely understand who has a burden of proof. I understand who gets to ask questions of what people. But again, the purpose of all of these procedural rules is to make a very efficient and fruitful hearing, right? Because there's nothing worse for a judge. And I've done thousands of cases and thousands of decisions. I've written tens of thousands of pages of decisions where the parties did not make it clear to me what the problem was, or they didn't make it clear to me what their position was, So these procedures are designed, and they're really good in situations where you have people who aren't represented by attorney, to make it so the judge can understand it. Why is that important? Because the judge is deciding your case. And that's the bottom line. The judge is deciding your case. Okay. Any questions about that? And if there are, we can always talk about them after. Sir. Oh, thank you very much. So the question from the gentleman in the back is whether disinterested persons, i.e. observers, can sit in on a hearing. The answer is yes, and it's yes in two great ways. Number one, you can come down to the Office of Administrative Hearings and sit in on the hearing. Also, if you want to see what's going on, you can email our office and ask for a Google Meet link to it, and they'll patch you right in to the hearing. So you can sit in the comfort of your living room, or you can dial in, however you want to do it, if you want to just hear it and watch what's going on. Yeah. Any case that is not confidential, it can be viewed by the public. Yes, ma'am. Yeah, I think, sir. Yeah, so the question is there a calendar? We do not have a calendar that we publish on the website just because we run so many cases through. And that's probably a good idea. I think we're probably going to start working on that. But the answer is, all you have to do is call to the Office of Administrative Hearings and say, hey, I'm interested in listening in on an HOA case in the next 3 weeks. And typically we have more than a few every month. So that shouldn't be any problem. And they will just say, great, okay, there's this case, send an email in with that case number, and we will make sure that you can observe it either by Google Meet or by telephoning in through Google Meet. Oh yeah, examination of witnesses. So that's that part I was telling you about, questioning witnesses, right? Each side gets to question the other's witnesses, and each side gets to question its own witnesses. So that's called an examination of a witness, as it were. Parties shall conduct examination of witnesses in the order and manner determined by the administrative law judge. I have never had a pro se person come in and be upset because the judge said, hey, we're going to take this witness out of order because it makes more sense to do that. And it may be, because one of the things that OA tries to do is not only accommodate, primarily worry about making sure that everybody gets a chance to basically present all their evidence and argue it. But we also have to think about efficiency for the parties. We have to think about efficiencies for the witnesses. It's not a good thing to have somebody hanging around all day when they didn't need to be. So the judge can change the order of the witnesses to accommodate what we call judicial efficiency. Again, if the judge does that in a case that you're involved in, doesn't mean the judge forgot about who has the burden of proof or who has the right to engage in direct or cross-examination, which is another way of saying asking leading questions of a witness who might be adverse to your position. Judge will remember that, but the judge has the ability to do that again for judicial efficiency, okay? Also, and sometimes this is hard for folks to understand. my judges will, and they're very good, they're very adroit at what they do, and they're very good at making efficient hearings because, again, the judges need to understand clearly what the dispute is and what the evidence is that support the parties' respective positions and what the law is on that. So they have the ability to make rulings necessary to prevent argumentative, repetitive, or irrelevant questioning. I have in the past from folks gotten complaints about judges. And by the way, there is a process for filing a complaint, which has nothing to do with the case. It's kind of an extrajudicial thing that we do to make sure that our judges are doing their jobs correctly. But I've gotten complaints about, well, they didn't let me go. The judge stopped me from going into this area. And the answer is, well, that's what the judge is supposed to do. If it's an area that's being launched off into that's not relevant, the judge rightfully should. And if they don't initially, they will eventually say, okay, we're not going down that line anymore because it's not pertinent to the issues here. Tie that back into what I said about your complaint, right? You want to make sure that every issue in that complaint is in there, not only because the judge can't decide it if it's not in there, but also because you want to make sure that when you ask him questions that it's relevant to the petition. Everybody understand that? Or have any questions about it's a better way to put that, I guess. Okay. All right, let's move on. All right, now we're going to talk a little bit about closing argument. So basically so let's back up a little bit. So we've had our opening argument, right? We've had the person who has the burden of proof make their case by putting on their evidence, and then their witnesses have been questioned, all right? Then the other side has gone forward because the other side gets a chance to put on their witnesses to talk about their case, and the person who brought the case has a chance to ask their question. So we've gotten through all the evidence. So now we move into closing argument, okay? And closing argument is basically what I used to say was a time to wax eloquently, as it were, to summarize your legal positions and summarize how the facts support your legal positions. That's what closing argument is, just really tying it all up in a nice, neat bow for the judge. And again, the party with the burden of proof needs to be very cognizant of what they're doing there. Don't be scattergunned in your approach. You know, you need to just say, okay, here's what my issues were. Here's evidence from witness A. Here's the testimony from witness C. Here's the documents that I presented and were admitted into evidence. And that's why they demonstrate that I'm entitled to the relief I'm requesting. Okay. The sequence of the closing argument can be determined by the judge. Typically, it follows that order. The person who has the burden of proof is going to go forward and make their closing argument. The other side is going to make a responsive closing argument. Then the judge may or may not allow the person who has a burden of proof to reply to that closing argument. You know, typical Perry Mason stuff, kind of court cases. But it's important to do it that way because, again, the judges want to make sure, you know, basically we try to make sure that everybody's had a chance to tell their story, tell the story again, and make their arguments because we don't want to miss it, right? As judges, we have an objective duty under our charges under state statute to ensure that we understand the facts correctly and we apply the law correctly. And the only way to do that is to make sure we have a proceeding that is clear, concise, and to the point. Okay. Now, sometimes there are legal issues that may or may not be clear. And because of this, and typically this arises more when we have lawyer represented parties, but it can arise anywhere because it could come from the judge, him or herself. There's a legal issue that's unclear or something else like that. And the judge will ask the parties for post-hearing briefs. Okay, not frequently, very rare, because most HOA cases are fairly straightforward, but that is a possibility. Okay, and that's not a problem for some, in my opinion anyways, it's not a problem for somebody who's representing themselves in these cases because they already took the time to write a detailed complaint, right? So that the judge would know what all the issues were. Doesn't always happen, happens more frequently in other bigger cases we do. And I don't mean by saying bigger, I don't mean to demean HOA, those are extremely important. All our cases are important to us, but more, I'll say more complicated cases that have been 15 days of evidence about whether, you know, some fish living in a pond somewhere in Southern Arizona is protected or not, something like that. Okay, so the ALJ may require closing arguments supplemented by written memorandums. And they can do it simultaneously. It's actually in the order the judge decides. And if the judge were to do that, he would give the parties sufficient time after the hearing to make sure they could file their closing memorandums. Just something to be aware of. Any questions about that? Sir? Oh, I'm sorry. Gosh darn it. Thanks, Augustus. So the question is whether the administrative law judge is required to take a filing if a party, particularly a brief, right, related to closing arguments, required to do that. The answer technically is no, but again, the judge is concerned with executing his or her duty to get the facts right and get the law right. So if it's requested, and that's not a bad idea, if you believe that something's unclear, or you believe that it can be made clearer in briefing, to ask. You can't hurt to ask, but the judge is not required to do that. Oh yeah, he's a lawyer. He deals with this. He knows. I'm just a judge, you know. I just think of the judge's perspective on this. All right. All right. All right. Admissibility of evidence. And this is one of the things I mentioned a little bit earlier about the fact that one of the beauties of the Office of Administrative Hearings is we have a lot more leeway in admitting stuff. Now, the fact that we have leeway doesn't mean that you won't have to do things like show that it's relevant to the hearing. You'll definitely have to do that. Not terribly difficult to do. And if Augustus disagrees with me on that, he can broach that point later. But it's very simple to do. And very typically in the HOA cases, there's not a lot of dispute about the documentary evidence. People almost invariably always stipulate to having it admitted. But this is the beauty of a proceeding before the Office of Administrative Hearings, especially for an unrepresented party, right? Hearing can be conducted in an informal manner and without adherence to the rules of evidence required in judicial proceedings. Neither the manner of conducting the hearing nor the failure to adhere to the rules of evidence required in judicial proceedings is grounds for reversing any administrative decision or order if the evidence supporting the decision or order is substantial, reliable, and probative. Okay. From a layman's perspective, that's a good thing in my opinion. Actually, I think from an attorney's perspective too. You know, it not only makes it easier, it makes it more conducive to what an administrative process is designed to do. One of the reasons we don't have the rules of evidence, and a lot of folks don't understand this, for example, even from attorneys, not Augustus, but other attorneys, I'll get hearsay objections and I'll say, who cares? I'm trained in the law. I've been practicing law and been a lawyer, been a prosecutor, been a judge for, you know, over 3 decades. I can sort that out in my mind. So hearsay objections, typically, great. It's hearsay. That goes to what's called the weight of the evidence, but not its admissibility, right? The judge may say in his or her mind, yeah, you know what? That's so far removed hearsay that I'm not going to accord it any weight, right? It's not going to really be substantial, reliable evidence. But that's for the judge to decide, not for the parties to decide. So that's the beauty of it. The other thing that's nice about it is it makes these proceedings a lot more efficient. I have been in cases before. For example, in Montana, as an administrative law judge, I did a whole bunch of other things besides what we do here. We did human rights discrimination complaints. The full rules of evidence apply to those things, as well as the rules of civil procedure in judicial court proceedings. You cannot imagine the rabbit holes we chased down trying to figure out whether a particular piece of evidence was or wasn't hearsay, you know, was or wasn't authenticated. Don't have to deal with that here. And that's good because the judge can sort that stuff out. And the judge will sort that stuff out because the judge is constrained, right, to make a decision that is based on substantial, reliable, and probative evidence. And they will do that. So that's one of the beauties of being in an administrative form. And boy, if you go to Superior Court, you're going to have fights all day about that kind of stuff. You just are. The other thing is that, so what's the upshot of this? Basically, administrative law judge, the Office of Administrative Hearings is going to admit evidence as long as it's relevant, right? i.e. as it relates reasonably to the petition you filed. the judge is going to likely admit it. That doesn't mean the judge always will, because the judge may say, well, that's not relevant, you know, and most of the time, I venture to guess 99% of the time judges get the right, but every once in a while they get it wrong. But typically, the only objection that might be considered is one of relevance. And everybody here understand what relevance is. It's a pretty low threshold. Actually, the threshold for relevance, this is your law tip for the night, is something that makes a matter and issue more or less likely. It's pretty straightforward, you know. If it has any kind of tendency to bear on determining that question, that's relevant. Okay, any questions about that? Seeing none, let's move on. All right. This is something I had included primarily for attorneys, but I think for homeowners, it's important. And here's one of the reasons why. One of the beauties of the Office of Administrative Hearings is we have a very accessible forum. And when you get home tonight, you get bored, go or do it tomorrow, go on the Office of Administrative Hearings website, and you'll see that we have the ability to file electronic motions. And instead of doing all these nicely, you know, spaced out with line number pleadings like would come from Augustus's office or any other attorney's office, you can go right in there and type out your motion into your case, and will automatically go into that case filing, and will actually allow you to serve it on the other side by email too. So it's pretty efficient. Gone are the days when we used to have to send pleadings by first-class mail to the other side. And that's another thing to keep in mind. Whatever you communicate to the court, if you're a party, you're going to need to communicate it that you're communicating to the other side, because administrative law judges in Arizona are strictly prohibited from taking any what they call ex parte communications related to the substance of the case. So, but I'm sure that won't be a problem with you folks. The motion practice in front of the Office of Administrative Hearings, particularly with respect to HOA cases, there is some, because there are sometimes some questions of law that need to be resolved before the hearing. And here's an example, you know, for example, an HOA might say, well, this kind of case isn't, you know, somebody sues an HOA and they say, well, this kind of issue isn't something that's within what they call the subject matter jurisdiction of the Office of Administrative Hearings when it adjudicates an HOA proceeding. You don't need to worry about subject matter jurisdiction. It's basically the Office of Administrative Hearings doesn't have the power to make that decision. So sometimes we'll get substantive motions in that regard, not frequently, but if we do, these are some important things to keep in mind about motion practice. There's that little AAC thing again in Arizona Administrative Code. Those actually R219 1 through 122 are the rules for the Office of Administrative Hearings. And don't worry about writing that down because it's all at the end of the resources if you ever want to look at it. But so these are just, and I'll kind of go through this. See, how am I doing? How much time are you going to want to be presenting, lad?
You're good.
I'm doing good. Okay. Oh, okay. We're splitting it down the middle. Copy that. Okay. Because I'm not going to get through most of this. I don't think. Okay. I'll pick up the pace here a little bit. So party requesting a ruling from administrative law judge has to file a motion. It has to be in writing. Very simple to do. You can do it through the Office of Administrative Hearings website. There are time limits involved. So unless there's good cause, it has to be at least 15 days before the hearing. Reason for that is to give the other party an opportunity to respond in writing and give the judge time to think about it. There's some exceptions to that. You can look at those. The party has to file a written response stating any objection to the motion within 5 days. The party can request oral argument on the motion if they want. I rarely see that. Every once in a while I do, and it's as simple as putting oral argument requested in the motion that you have filed. And then, bless you, sir. And then there's a little bit of discussion about the OAH electronic motion filing systems. Really simple to do. OAH actually was one of the first entities in the state to have its own website and its own filing portal, electronic filing portal. So been on doing that for, gosh, 25 years already. Any questions about that? Okay, let's go on. All right. Just keep in the back of your mind the most stuff. Now, I want to talk a little bit about the remedies when a violation is found. One of the things that OA can't do, and you know, if you are in a position, let's say you want to sue your HOA or the HOA wants to sue, well, the HOA wants to sue a homeowner. The parties, and Augustus will talk more about this, they have to consider what remedies are available, okay? The administrative proceeding of HOA complaints, it's not insignificant, but it's not a broad range of remedies. And I think I'm pretty safe in saying that. Why is that important? Let me think of a case. Recently, we had an HOA case where somebody was complaining about a lien that had been placed against their house. And they were arguing correctly. I don't know what the result was of the case, but their argument was, well, it violated CC&R or something, all right? But the party also wanted to get the lien reimbursed. As the statute says very clearly, there's basically two things a judge can do in these cases. We can order a party to abide by the statute, condominium documents or community documents, or contract provision issue, and then can also levy a civil penalty on the basis of each violation. So order somebody to abide by the rules, the condominium rules, for example, or levy a civil penalty. What's not in there? Reimbursement on a levy. It's just not there. It's not possible. So you want to, Augustus has a question. Yes, sir.
So who gets the civil penalty? So if the OIH issues a civil penalty against an actor, where does that money go?
That money goes to the Department of Real Estate.
So it doesn't go to any other parties.
No, it does not.
Department of Real Estate.
Yeah. It goes to the Department of now, and that's a separate question from the filing fees, because those can be regained, as it were, recovered, I guess, a better term, for the prevailing party in one of these cases that they file a filing fee. And I think Augustus will probably talk about those filing fees a little bit more. But yeah, it goes to the Department of Real Estate. So. All right, and then that's the second part. If the petitioner prevails, the administrative law judge shall order the respondent to pay the petitioner the filing fee required by section 322199.01. All right. So one thing Augustus mentioned earlier was you can't get attorney's fees levied against you, and that's attorney's fees are always huge. I don't know, the cheapest attorney fees I've ever seen recently, even in an uncomplicated Superior Court case, are probably in the neighborhood of $3,000 to $5,000. You know, if it went very expeditiously. I believe the Department of Real Estate right now charges $500 per issue, up to 4 issues, I think, right? I don't know. I'm not keeping up on what they do, but
500 for a single issue, 1,000.
Oh, for multiple issues. Okay, I couldn't remember what it was. So do the math, right? And again, I'm not touting one way over the other. There may be times where a parties just decide, you know, Superior Court's the only way to go because it's the only way we can get the relief we're entitled to. But what Augustus mentioned is absolutely true. It's a lot cheaper to take the route through the Office of Administrative Hearings. You decide with your own intellect or with your lawyer. All right, any questions about that? Seeing none, let's go. All right. I want to talk a little bit about HOAs. I have dyslexia these days. HOA, OAH, whatever. It's kind of unique, at least from the administrative perspective, about what happens post-hearing. So this is a situation where the judge has rendered a decision, okay, an initial decision. That decision will become the final decision unless a party takes action to request a rehearing within a certain time frame. And I'm not going to go into the time frames. They're in the statutes and they're in the resources that we're giving you. So if a party's satisfied with the decision, that'll become the final decision within an X number of days. If they're not, though, they have a remedy a very specific remedy. They have to request a rehearing from the Department of Real Estate. What does a rehearing mean? If a rehearing is granted by the Department of Real Estate, and there's some procedural requirements within that request for rehearing that have to be followed, and I'm not going to worry about those tonight, but you will want to pay particular attention to those if you're dissatisfied with the decision of administrative law judge in a case. It goes back to the department, and the department says, okay, well, for a list of specific reasons, and I think there's 6 or 7, I don't remember what they are, but they're contained in the statute. In ARS 322199, they can actually, it's in the rules that apply to the Department of Real Estate. That's one of the other things too. There's a little bit of I guess it's kind of scattered, as it were, because rules that apply to the Department of Real Estate can also pertain to an HOA case. And in fact, they do, especially in the pre-hearing process, but also in the rehearing process. You're going to want to be aware of those. But again, we have all those resources contained at the end of the PowerPoint. So you have to do it within a certain time. There's an opportunity for the other side to respond. And then the director of the Department of Real Estate decides, yes, I'm going to grant the rehearing, or no, I'm not going to. If the director of the Department of Real Estate grants the rehearing, it comes back to the Office of Administrative Hearings. And I think I'll just go on to the next thing. It comes back to the Office of Administrative Hearings. And here's the grounds. I forgot. It's been so long since I looked at this. Here's the grounds for rehearing that are articulated in R4 281310. That's that same Arizona Administrative Code, but this applies to the Department of Real Estate. Not per se, doesn't apply to the Office of Administrative Hearings, but again, it's there, it's in the resources. So you have everything you want in one nice one-stop shopping at the end of the PowerPoint, as it were. So those are the grounds. Okay, and the order has to grant with granted, has to specify with particularly the grounds on which the rehearing is granted. The rehearing will cover only those matters specified. So let's say we had 10 issues or whatever, 5 issues, let's say that for you. And 3 of them were decided against the petitioner and 2 were decided in favor. And the judge says, well, I'm going to grant a new hearing because this wasn't, one of these issues should have been decided, there was error in it. The Department of Real Estate has to specify, if I said judge, I didn't mean to say that, I say Department of Real Estate. They have to specify what areas are going to be covered in the rehearing, and then only those matters will be done. Why is that? Because this process is really a winnowing process. Everybody know what I mean by that? Trying to funnel this down to not make it a greater, more exacerbated, more extended hearing proceeding. So you want it to funnel down to only the area where the error was perceived by the Department of Real Estate and then sent back to the Office of Administrative Hearings to have a rehearing on that issue. And I don't blame folks. Well, I'll tell you this, even attorneys have problems sometimes understanding that, but my judges don't, right? Because again, this process is a narrowing process. It's designed to be efficient so that the judge can understand, so the judge can get the decision right. Sometimes they don't. That's human nature. We're all human and we're fallible. But my judges will stick by that rule, okay? So they will not allow parties to go off into matters that were previously litigated, but not specifically specified as a basis for the request for rehearing, okay? And then at the rehearing, it's basically, a lot of times our rehearings end up being just legal questions, and that's when the briefing might come in. Or the parties will stipulate, like parties can agree, yeah, we don't dispute this fact happened, we don't dispute this fact happened, and we don't dispute that this is a document that covers it. So the judge will get the parties together and say, well, if there's stipulations, we'll just put the stipulations in and I'll render a decision on the rehearing in due course based on these stipulations. And that's a very frequent occurrence. So I think most folks understand it's a winnowing process. Sometimes they don't. And when the judge says, I can't go there, don't hold it against the judge. The judge is just following what the rules say. Okay. Any questions about that? Okay. All right. So on the rehearing, once the judge issues that ruling, that is the final decision. And there is no more recourse in the administrative process. A person has to go on appeal to Superior Court. We had this wonderful case that, sir.
Who's the bad guy who actually made that case law?
Yeah, well, I didn't say bad guy, I said the wonderful guy, yes, sir. Yeah, yeah. Yeah. The order issued by the administrative law judge is enforceable through contempt of court proceedings and is subject to judicial review as prescribed by section 4110-9208. So let's say a homeowner, the HOA, and I'll just basically loosely describe the facts of Whitmer. HOA, the homeowner perceives that they haven't complied with what the administrative law judge ordered them to do. OA has no ability to enforce that decision. We are an administrative agency. We have no authority to do that. The person has to go to Superior Court to do that for a contempt proceeding in Superior Court. That's essentially what Whitmer versus Hilton Casitas was about. Mr. Shaw is going to talk to you a little bit more about that. But it is what it is. We'll have to have a discussion about that someday, because frankly, when I saw the original decision in Superior Court, I was kind of flabbergasted. I'm like, wait, what? But that's not for here and not for tonight. It's for another time over a beer. Okay, so these are the resources, and I don't. Yeah, so if everybody wants the PowerPoint, those are live links. I think they are. Yeah, I don't have a.
They're all live.
Yeah, they should be.
Yeah, Greg, we'll go ahead and send those to everyone. Also, Greg,
Okay.
we had a quick question for you.
Go ahead.
From Carolyn, the HOA is refusing to do maintenance on perimeter walls facing common area. The stucco has deteriorated and also the dirt has eroded away from the fence, exposing the bare back or the bare block below original grade level. Is this one or two issues?
I'm going to leave that for Mr. Shaw to do that. Do you
Okay,
want to
perfect,
answer
will
the
do.
question since you're? Go ahead. Because I'm loath. Stand by. The reason I'm not answering it too is I'm a little bit loath to get into that because I'm with the judges. So
Yeah, he actually has to make that decision. So I would say it's two issues. It's two breach of contract issues. The first breach of contract is the failure to maintain, right? The exterior. And then the second breach would be the failure, the result of the breach, which, as Greg said, you cannot get damages at this tribunal. So it would be two. You could probably squeeze it into one because you're not going to be able to get damages as a result of the breach of contract.
Oh, thank you for getting me out of that situation. Yeah, I should have qualified that. Because I am a judge, even though I don't do these cases anymore. I can't speculate on hypotheticals, as it were. Typical government answer, right? But it's true, and I don't want my lunch ticket pulled because I did that. Yes, sir. So the question was, who determined who had the Department of Real Estate get involved in this? The answer is it's actually from 2016. The HOA process was begun, I believe, in 2007. And originally it was done through the Department of Fire, Building and Life Safety. But there was at least potentially constitutional problems with that happening. So in 2016, they designated the Department of Real Estate because it does have some enforcement authority in the condominium and planned development community areas to enforce that. So it was transferred over to the Department of Real Estate at that time. But again, in terms of, and I'm not trying to allay any fears, but in terms of understand this, and I don't mean this pejoratively, but in the law, we used to talk about something like the wall of China that separates, right? It's a wall that nobody can go over, at least it used to be that way. That's what we have between the agencies. The Department of Real Estate is a completely separate agency. I don't care what they think. I don't care what they do. I care that when I have parties in front of me, they get to tell their story. I make the decision based on the law and the facts. I don't care what they do with a post-hearing petition. None of my concern. I care that I do my job and that's it. So does that answer your question? Yeah, it's a statute. The legislature decided it ostensibly.
Okay, yeah, I didn't think it was on. The legislative intent was to give owners the ability to have a tribunal without facing the fear of being having attorney's fees ruled against them. Because as Greg pointed out, I'm good at what I do, and I charge a lot for it. So I can get $30,000, $40,000, $50,000 award of attorney's fees against owners for bringing a legitimate question to the Superior Court, but they don't understand the rules of evidence, the procedures in the Superior Court. You know, a lawyer can use their superpowers, and next thing you know, a legitimate concern is now a $50,000 bill.
And along those same lines too, the legislature's purpose was to make it a much more efficient process. Augustus can tell you how long it takes to run a civil case through Superior Court. It's a long time. At the Office of Administrative Hearings, upon receiving the petition, we have to set that matter for hearing within 60 days. Sometimes we continue it because it's more, the parties need it for extraordinary reasons, but you understand that it's 60 days to the hearing typically. It'll be another 20 days till the judge's decision comes out, assuming there's no post-hearing wrangling with the request for rehearing, which sometimes there are a lot of times there is, but that's okay. That matter will be cradle to grave, as it were, probably within 100 to 110 days. You're looking at 2 to 3 times that long in Superior Court. I know, I'm
Longer
old
than
school,
that.
man. I'm way back in the day, so.
We've got a question from Joan. Do you have to go to the real estate department first before having a hearing at the OAH?
Yes, Joan, so the question was already articulated, the folks who are remote. Yeah, and my bad for not making that a little more clear. I think Augustus is going to talk a little bit more about this. But the process is initiated through the Department of Real Estate. And then through the complaint process, party files a complaint, there's a chance for response, and they send it for hearing over to the Office of Administrative Hearings. So you have to go through the Department of Real Estate because it really is administered by them. The only function that OA has in it is to adjudicate the matter, independent of any influence from the Department of Real Estate. Any other questions, folks? Sir? Oh, yeah, go ahead.
It's in your presentation and it's also in the notes that Augustus gave here. I want you to clear something up for me. Recent case law suggests that the administrative law judge does not have the power to conduct contempt of court proceedings regarding ALJ decisions. What's the point of going through all this if I'm going to be forced to go to Superior Court to resolve something?
Well, I guess the first thing I back up on is say that's your legislature's decision, not mine. It's very specific in there. Perhaps that's a downside of it, because at this point, administrative tribunals in Arizona, with the exception of the Corporation Commission and perhaps Industrial Commission, do not have contempt authority, and the legislature has never sought fit to grant them that authority. So, you know, I would say, and Augustus probably can handle this better, because I haven't had a lot of cases where people were concerned about that. There have been cases though, you know, where they said, you know, for example, HOAs, homeowner saying the HOA is not doing what they're supposed to do.
If we really want to get esoteric about it, it's a separation of powers issue. Because and correct me if I'm wrong, but the administrative courts are still an executive branch power. So contempt issues should really be handled on the judicial branch power. So I would say it's a separation of power issue.
Until there's a qualifier on that, until such time as the legislature were see fit to grant a limited power of contempt, which they could do. There's states across the country where they've done that. So, yes, ma'am. Not much of an answer
Thank
for you,
you,
was
sir.
it? Sorry about that. But it's an honest answer.
I'd like to follow up on the contempt of court and the procedural issue. So a homeowner files a complaint against, let's follow up. Let's use that example given by one of the people it's online about the fences not being maintained. So a homeowner files a complaint against the HOA. It's clear that the CC&Rs and the architectural rules state that that is the HOA's responsibility, presents the evidence, the administrative judge rules that yes, the homeowner is correct and the HOA is at fault. Correct. So there's the administrative law judge makes a finding or a judgment, correct? Okay, now let's
Yeah, a
say.
decision. They issue
Right, a decision. Now, I'm sorry, sir, Mr. Shaw?
Yeah.
Yeah, so as Mr. Shaw was explaining, if that homeowner instead went to Superior Court, of course, then they have the potential of racking up all of the attorney fees. But they've prevailed now with the OAH. Now the issue is one of contempt. So if the HOA doesn't follow the decision made by the administrative law judge, now we have an issue of contempt. Now, if the homeowner chooses to go to Superior Court, it's no longer it's not relitigated, is it? In other words, the decision has been made.
Greg, if you mind, since I litigated that
Go ahead,
case.
go ahead.
So I'm the one who litigated the Hilton Casitas case. So the way it would work is that in Arizona, the final judgment of the Arizona Office of Administrative Hearings is a enforceable judgment, is a judgment of a court of record now pursuant to Whitmer. So then you have to go to Superior Court if you want injunctive relief. That's the law of the land. So the Superior Court could order, in your example, the association to abide by the OAH's judgment within a certain amount of time or face penalties and things of that nature. You are entitled to your attorney's fees. Well, you're not entitled. It's a discretionary matter as to whether the court will grant you attorney's fees for seeking the contempt order. So if the court finds the association in contempt, then you're likely going to get the attorney's fees you incurred seeking the contempt order. Does that answer your question?
Yes, sir.
Okay. No, the judgment is a final judgment. So you're not relitigating the issue. The only question you're answering is the HOA abiding by the judgment, or in this case it would be order, of the OAH? Because it's not a judgment, it's an order, which is a technical term that is very important.
That's correct. Yeah, you can't relitigate it. It's what with the law business we call a collateral attack. It's not allowed. So it's only the question of whether or not they failed to the entity that was ordered to do something failed to do that. Hold on a second.
Oh, I'm sorry. It makes sense then. I mean, I understand the gentleman over there is saying what's the point, but it does make sense for a homeowner who has less, perhaps less of the financial ability than the HOA to take this first step. So now you find out, I have a case that won, whereas maybe your case isn't that good and you don't have to pay Mr. Shaw.
And that's in my opinion, that's the beauty of this procedure, is that if you are a homeowner and you have a weak case, it's going to cost you your filing fee, but you'll get your day in court. Versus if you go to Superior Court and you have a weak case, you're going to pay a filing fee and you may have to pay attorney's fees because the case was weak.
Any other questions for me? Which is fine. I'm
Oh,
happy.
no, this is the guy. He's the decision maker up there. So any questions on
I
how
know the
procedure and things of that
decision-makers.
nature,
I'll
he's
put
the
it
guy.
Yeah. Yeah, it's not as complicated as it might seem. It's really fairly uncomplicated compared to, I'll tell you what, I'll start with the lady up front, then I'll go back to the gentleman in the shirt. Yes, ma'am. Stand by. Stand by. He's going to bring you a microphone.
We read in a book on HOA power, which we found out we don't have a lot of power against a board. if we bring an issue in front of your hearing against a board member, and yes, you find that that board member did violate every issue that we listed, what then is the result? What reprimand happens to that board member?
Well, I would just say this, the parties that can be sued in that thing too are limited, but again, that goes back to that notion of remedies. What can they do with the Office of Administrative Hearings? They can order the HOA in that section to abide by the rules, and they also can level a civil penalty in a certain amount, and that's the extent of the remedies.
Under the statute, a board member is not a proper party.
Yeah.
So you could not file an action through the Arizona Department of Real Estate against a board member. They're not a proper party. And we'll talk about proper parties in a little bit.
Yes, sir.
How do I influence what the legislator is going to talk about? Because they just spend an inordinate amount of time talking about political signs, flags, artificial turf, and some other things that
Well,
aren't
find out
big
who-
hit items to
Find out who
me.
your representative is and talk to them. Find out who your representative is in the Senate and in the House and talk to them.
Call Mr. Kavanaugh. He's probably your representative and he'll listen.
Yes, sir. Hold on a second. We'll bring you the, Augustus has got this gentleman up front. It's a good thing you have your tennis shoes on tonight, buddy. You're running around. Yes, sir.
Greg, can you give us the statistical breakdown on who prevails when the members sue the association? I've heard it's roughly 1 in 10.
I don't know what it is. It may be more or less than that. Well, it's probably not less than that. I guess my perspective on that is, and I don't mean to demean your question, but I think that's a meaningless number because every single case has to be decided by the judge based on the facts. So not to pose a question back, because I'm not here to ask questions tonight. You know, I've heard that too. And, you know, last month I saw, I don't keep up on all the cases, so I don't know how many do, but I think that parties that come to OA can rest assured that the judge will make the decision based on the law and the facts. And even if, you know, statistically, if it was 100% one way or 100% of the other, if the judge is doing his or her job, right, and it's based on the facts and based on the law, then I'm not sure what that means. So that's Greg's answer, but I don't know. I would venture a guess that you're correct, at least that probably more frequently the respondent prevails than the petitioner.
And
that's almost
can I-
certainly true.
And I like to comment about Greg's judges. It's you can't go into those hearings and use your lawyer superpowers. It's not about legal trickery in those hearings because of the curtailment of the rules of evidence and the discovery and disclosure rules. So there's a lot of things you just can't do. So it really does rely on your documents and your witnesses. It really is it's the purest form of litigating. And so I would venture to guess to say that if those numbers are correct, maybe it's the, bad facts, make things difficult.
And realize that the judge is constrained because it's a crucible in that hearing room. The judges weren't there. They don't know what happened. So they rely on the parties to bring them the information.
And the judges are very good. But we do have to move on, Greg.
Oh, this lady had one more.
Okay.
Okay. I'll get out here and let.
So I'd like to thank Greg because, he doesn't get paid overtime because he's the boss. So thank you for doing this. For him to come out, to us and give us the benefit of that knowledge.
Scottsdale.
Well, it's awesome. So I'd like to thank you for doing that, Greg. Oh, you have a question?
Yeah, we have one more question. So if the HOA ordered to abide by the CC&Rs and doesn't, do I go to court again, or does the Supreme Court just make the judgment and order them to abide?
So you'll have to go to the Superior Court to seek enforcement of the Office of Administrative Order. So that's something you'll have to file a new action in Superior Court. It's a contempt of court action, and it's a brand new action in Superior Court.
Okay, and she had a follow-up. She said, sorry, if I win in OAH, do I need an attorney to go through Supreme?
So to go to the Superior Court, you can represent yourself if the judgment is in your favor. I wouldn't recommend it, but you can represent yourself. Greg, you're gonna, yeah.
Was that case in the Whitmer matter? That was a pro se, yeah.
Yeah, so Whitmer represented himself quite adequately. He's a very smart man and a good man. He's a great guy. Okay, so what I want to do with the remaining 20 or so minutes is I'd like to go back through what Greg talked about and just basically give you some pointers from an owner perspective on how to navigate through the process, and then give you some pointers on how to beat a guy like me. Because 9 times out of 10, if you file an action at the Arizona Department of Real Estate against an HOA, and the HOA is going to have an attorney. It's very rare that they won't. Some self-managed associations will go at it on their own, but most associations will have an attorney. So let's go through it quickly. So first of all, we have to understand who can avail themselves of this procedure at the Arizona Department of Real Estate. And as it was commented on in a question, right, there are 2 distinct aspects of this entire procedure. There's the beginnings with the Arizona Department of Real Estate. So you begin at the Arizona Department of Real Estate. You can go on to their website, Arizona Department of Real Estate, and they have a tab that says HOA disputes. And in that tab, they'll have all the information. They'll have a form complaint and things of that nature. So you start with the Arizona Department of Real Estate, okay? They will have a complaint form that you can fill out and you can supplement with specific facts, okay? Greg was correct, I was incorrect. Go figure, right? Greg's always right. Every single action is $500. There is no maximum number. So if you have 5 actions, it's going to be $2,000. Okay. Now, when you fill out your complaints, don't be lazy. Okay. Use as much ink as you think you need to list out your case. Tell your story on that complaint form. They will allow you to supplement it with additional pages. You don't have to fit everything on the form, but make sure you tell your story. Why do I say that? Because as it goes through the process, what you are asking for is going to be narrowed. So you want to be very succinct and clear regarding what you are asking for. 9 times out of 10, it's going to be what's called a breach of contract. The association failed to do something that they were obligated to do. The obligation is based on the contract, the CC&Rs, the Articles of Incorporation, the bylaws, the rules and regulations. So the vast majority of these complaints from the homeowner side are going to be breach of contract. The CC&Rs say that you have an obligation to maintain the exterior of the building. The association is not maintaining the exterior of the building as required by the CC&Rs. And I want an order ordering the association to maintain the exterior of the buildings. So list out what the issue is, what the contract is, which 9 times out of 10 is going to be the CC&Rs. And it's important, I want X. I want X. Okay, that's the most important part of the complaint. The factual part, the story of why you want X is also important, but not as important as listing out what the cause of action is and what you want. Okay, that complaint form is also going to ask you to list out how many witnesses you may need. Be liberal with that, because you could be bound by that number once you put it on that piece of paper. Okay? Think about it. You know, don't just say, well, I want the entire board of directors when you really only need one person. Okay? But then again, don't limit yourself either. Now, the parties that could be a part of this process are members can bring an action against their HOAs, their associations. Members cannot bring an action against other members or against their management company. Okay, so board members are out. You have to bring an action against the HOA. Also, if you believe that this is all the management company's fault, you can't bring an action against the management company. It only can be against the association. Okay? Now, you're going to go to the Department of Real Estate, and Greg, please correct me if I'm wrong on any of this. You're going to go to the Department of Real Estate. You're going to fill out your complaint form. You're going to file it. Okay? Now, the association will have the opportunity to respond. The Department of Real Estate will offer the parties the ability to mediate the dispute before it goes to a hearing. Okay? Take advantage of that. Don't automatically say, no, I don't want to mediate this, right? Again, I'm in favor of mediation because a lot of these disputes are really, they're misunderstandings, quite frankly. They're misunderstandings, or they are based on not having knowledge of the actual documents. Like I always like to say, you know, just because something isn't fair doesn't mean that it isn't legal, right? Just because something isn't fair doesn't mean it isn't legal. And sometimes we would perceive something as being not fair, but under the CC&Rs, it's 100% legal. So, you know, you'll be given the opportunity to mediate it. You may really want to consider that. Mediation is not obligatory. It's an option, okay? So, yes, please.
Just real quick too. That mediation facet of this, for those of us who are trained mediators, I've been doing it for about 10, 12 years. I don't do these. OA doesn't do mediations for this. The Department of Real Estate gives other options, but where you have a process where you have an ongoing relationship, mediation can be very effective. And I can't think of a more critical relationship than a homeowner and a homeowner association, right? Folks buy their houses because they want to live where they want to live, and they want to have amenities they want to have. And on the same token, the HOA wants to provide those. They should want to provide those amenities because that's what they exist to do, right? I mean, that's why you have a group of people who run it. They should be doing that. So I think mediation is a serious consideration and is a useful tool to resolving the disputes to promote that ongoing relationship.
And it is in the association's interest to really consider mediation because, again, likely the association is, likely the association is going to either tender the whole thing to its insurance carrier, and the insurance carrier is going to hire an attorney for the association, or the association is going to go out and pay for their own attorney. In any event, that's a lot of money that's going to be out of the association's coffers. So mediation usually is the best way to go, and filing a Department of Real Estate claim is a way to get mediation in a manner that's more forceful, where the HOA may actually accept it, okay? But let's say you don't, mediation is not accepted. It's just an issue that cannot be mediated. It is a true disagreement of the facts or the law, okay? Now you're going to go to the OAH, and the OAH is going to start the process of litigating this. Now, the judge will issue a notice of hearing. And again, if I say anything incorrect, Greg, jump in.
Actually, it's the Department of Real Estate that issues it. The OA sets the hearing, but the Department of Real Estate issues the notice of hearing in the matter.
So Greg, what I was going to say is, in that notice of hearing, the question that's being presented to the court will be clearly spelled out. Yes, Greg? Okay. This is an important point in this process because the court is not going to entertain questions that are not listed on that notice of hearing. So if you get that notice of hearing and you say, well, that's not what I'm asking for at all, you want to bring that to everyone's attention before you move forward. And also understand that you're going to be bound by that statement of what the issue is, okay? I will use my lawyer superpowers and I will limit your argument to the question in the notice of hearing. So if that's not what you want, that's what you're going to litigate. That's one of the ways that I can use my lawyer superpowers, okay? So be very clear, read that statement and say, yes, I want the court to determine that the association has an obligation to maintain the exteriors of the buildings, okay? You want to make sure that what's in that statement is what you want. So you're going to get to the hearing. Now, one of the things that you can do is, and I do this a lot, is I ask the judge's permission to provide the judge a written document that's going to detail my legal arguments, my facts, and present to the court ahead of time my potential evidence. Now, what I will do is I'll go to the other side and say, okay, let's go to the court and let's do it together. You present your facts, you present your law, and then we get together and agree on what the evidence will be, and then we can stipulate to that statement and give it to the judge ahead of time, right? The reason why that I feel that that's a great idea is that the judge will see that ahead of time, and it makes the hearing go a lot quicker. We all know what the facts are. We all know what the evidence could be. We all know who the witnesses are going to be. We all can highlight the areas of law that we're going to argue and the facts we're going to argue, right? Now, that's a very technical thing for a non-lawyer to do. Please don't take that the wrong way, but it's something that you may be presented with from another attorney. It's not a requirement. You don't have to say, yes, I want to do that. You can say, no, I want to go forward with the hearing. But again, it's an opportunity for you to say, okay, attorney, let's agree that the CC&Rs are important here. Let's agree that the bylaws are important. Here's a couple of letters that I got from the board of directors regarding this. Let's agree that these letters will be considered. I want to call these witnesses. Let's agree that we can call these witnesses. Again, it just gives you a roadmap to make the hearing go a little faster and a little smoother, but it's not required. As Greg pointed out, the burden of proof is going to be on the petitioner, okay? So when you present your case, what I would humbly suggest is that you really concentrate on what you are asking for and why you are entitled to it, okay? I have a saying, never litigate on principle, right? Keep it to the facts and the law. And remember, just because it isn't fair doesn't mean it isn't legal. So just make sure that you're very succinct, present your evidence, but don't try to bring in other areas that were not contained on that notice of hearing, right? Because the other attorney is going to say, wait a minute, Your Honor, what they're arguing is not on that notice of hearing. That's not the issue before us today. And, that's going to be problematic, okay? Again, try not to be emotional, just matter of fact, because the goal of the tribunal is to get to the truth and to fairly adjudicate the rights of the parties, okay? Those administrative law judges, he trained them all. You're not going to get anything past them. You're not going to be able to use legal trickery. You're not going to be able to play on their emotions. You're not going to be able to turn on the waterworks and sway them. They're really disciplined judges. They've seen all these issues. So they're going to look at the facts. They're going to look at the evidence. They're not going to, they're going to listen to everything, but they're not going to stand for the legal trickery. And let me give you an example of that. I was before one of the administrative law judges a couple of months ago, and I forgot that, the rules of evidence are loosely applied. So I was objecting like crazy, objection, leading question, objection, hearsay, all the objections. And the judge, to her credit, finally said, Mr. Shaw, you've been here enough to know that I'm going to weigh the evidence how I'm going to weigh the evidence. And I looked at her and I said, you know what, Your Honor, that's absolutely correct. I will stop interrupting this witness's testimony. Because again, unlike Superior Court, those judges are going to listen to the witnesses and they're going to weigh the testimony as they feel is appropriate. They know what they're doing. So to reverse that, ask your questions, but don't try to, Perry Mason it, as we would call it. Don't try to use legal trickery, because it's going to fall on deaf ears. Okay? So the hearing is over and you've won. The court has agreed that the association has an obligation to maintain the exterior, and the court has ordered the association to maintain the exterior and has ordered the association to reimburse you your filing fee. So you've won, right? Now, there will be a certain amount of time that the association will be given to implement the order, okay? So you just have to understand that there will be time to implement the order. As we've been discussing, if the order is not implemented by the association within a reasonable amount of time, then you will have to leave the Arizona Department of Real Estate, Arizona Office of Administrative Hearings procedures. You'll have to leave that and then go to Superior Court for enforcement of the order, okay? Let's say you lose, but you feel that and we're gonna jump ahead. You feel that I'm gonna jump way ahead here because I know we saw, okay. You feel that that the ruling was insufficient because of one of these reasons. You can ask for a rehearing. Now, I do want to take some time, however, to go through these, right? Because yes, the Department of Real Estate is going to be making the determination on the rehearing, but you may look at some of these rationales and you'll say, well, of course. The first one, irregularity of the proceeding, okay? That is a super hyper technical term. And what we have to remember is that the rules of evidence don't apply. So simply feeling that the judge didn't allow you to interview a witness the way you felt the witness should be interviewed wouldn't necessarily be an irregularity of the proceeding. Now, if the judge said, I'm not going to hear any of your witnesses, that would be highly irregular. Or if the judge interrupts you during your examination, that could be an irregularity of the proceeding. I don't think it would ever happen, but it's so this one you may say to yourself, well, I feel that the hearing wasn't fair. So because it wasn't fair, it was irregular. They don't add up all of the time. So just understand that. The next one is misconduct by the department, administrative law judge, or prevailing party. Again, someone intentionally acted in an unprofessional or illegal manner. It doesn't happen, but it could. That's why it's up there, right? But you're going to have to really display and prove what the misconduct was. And I guess an example of misconduct would be just an administrative law judge just not allowing you at all to present your case. So the administrative law judge comes in and she says, okay, I've read everything. I don't want to listen to the petitioner. Respondent, do you have anything? No? Okay, great. Thank you. Have a nice day. Which wouldn't happen. Right, Greg? That wouldn't happen.
You're right about one thing. I can just say this. So there is a provision in the statutes that allows for a party to request a change of judge based on bias or the judge's perceived lack of technical expertise in the matter. HOA, there really isn't any technical expertise. The statutes are what they are. Well, there's lawyer expertise, but I don't know that those are the same. It's not like we're dealing with leaky underground storage tanks or something, but the standard, for example, for bias of the judge in Arizona is pretty well laid out. And the fact that the judge heard facts and ruled against you in a case doesn't demonstrate bias under Arizona law. Basically, it has to be the judge knew you from down the street and hates your guts. There's a lot of case law about that. So if that ever did happen, I'd have to have a serious talk with the judge or fire the judge, because that's just not going to happen, Noah. It's flat out not going to happen.
So let's move to the next one, which is a possibility. Accident or surprise that could have been prevented by ordinary prudence. This is the old gotcha witness, the smoking gun witness that, and again, it's difficult in the administrative law judge because the rules of evidence don't apply. But if the respondent brings in a witness that has documentation that completely disproves your case, right? You're going to lose the case anyway. But a good attorney would make you aware of that type of thing before the hearing to give you the opportunity to say, oh, wow, I didn't know that. Let's maybe go to mediation, or let's maybe not have the hearing. But it really has to be something that it shocks the conscience. Newly discovered material evidence is one that I've actually been successful on. Many of you may be aware of the new Supreme Court case, the Callaway case. They came out in March. That case has overturned many of my motions for summary judgments since it's come out. But that's a case that is a brand new case that has a profound effect on community associations here in Arizona. And that case does have the effect of overturning judgments and orders. So that would be a situation where a court maybe says in a Callaway scenario, the order from the ALJ would be that the association had the right through a normal amendment process to add in a rental restriction. So the administrative law judge in April says, yes, the amendment process was proper. The amendment is proper. I'm finding for the association, the rental restriction is proper. Well, then Callaway comes out and turns that on its head. So you could go back to the administrative law judge in a rehearing and say, the administrative law judge made this decision, but since then we have new case law that would materially affect the administrative law judge's legal rationale. And you'd have to explain why. And then that would be the newly discovered evidence or law. Evidence particularly, let's say you're litigating it on a breach of contract theory, but there's a document out there that says no act. An example would be, let's say that the CC&Rs say that the association must maintain the roofs. And you're bringing a lawsuit that says the association is not maintaining the roof, right? Unbeknownst to anyone, which I don't know how this could happen, but it's a good example. Unbeknownst to anyone, there's an amendment to the CC&Rs that was validly recorded that says, no, the members have an obligation to maintain the roof, not the association. But no one ever thought to do a search with the Maricopa County Recorder, and lo and behold, after the order comes out, someone says, hey, you guys knew about this amendment, right? That would be newly discovered evidence. I would argue, well, actually, you can't argue your way around that one, but an argument would be, well, through reasonable means, you could have discovered this evidence, but again, that's more legal superpowers and trickery. Error in the admission or rejection of evidence, again, the administrative law judges are going to allow everything in that's remotely relevant. So, that one may not be one that may be prudent. The finding of fact or decision is arbitrary, capricious, or an abuse of discretion. That's the one that's most often used to request a rehearing. That's the more amorphous one, and you could give it a good stab. Sometimes, the Department of Real Estate will, just out of an abundance of caution, will allow you a rehearing on that one. And then the last one, I'll have to stop talking. The finding of facts are not supported by the evidence. Again, that's a discretionary rationale that the Department of Real Estate will investigate. So I guess the whole point of me going through that list is just to highlight the fact that there has to be some serious shenanigans for a rehearing, and an appeal may be a better course of action than a rehearing, which is your second option once the order becomes a final order, and you'll get an issue, you'll get a document stating that the order is a final order. Then you'll have a certain amount of time to appeal it to the Superior Court. And that, again, if you believe that you want to avail yourself of the request for a rehearing, you can do that, but most of these issues are really appellate issues. There's a question?
Yeah, we have a few questions.
Okay.
So can I submit a petition with signatures of homeowners who are disputing the HOA, not maintaining walls, et cetera?
So can you? Yes. Should you? No, because you are the person that's bringing the complaint. So I think that you're trying to add additional names as evidence to support your claim. But you just need one person to sign the complaint to get the complaint filed.
Okay, perfect. Carolyn also says, I went in OAH and I have paid for repairs. Can I ask for the HOA to reimburse me because they were supposed to do the repairs?
So again, as Greg discussed, there are only two remedies that the Office of Administrative Hearings can issue. They can issue, they could require the association to come into compliance with the governing documents. So they can order the association to do something. And they can, there's three, you're right. I'm sorry, Greg. Yeah, level of civil penalty. And again, that civil penalty does not go to you. That civil penalty goes to the Department of Real Estate, and then you can get your filing fee back. This question deals with damages. I had to pay something as a result of the association's failure to act. Can I seek reimbursement? No, those are damages which are not within the statutory purview. What else?
All right, perfect. The last one is the CC&Rs are a contract between HOA and homeowners. AZ statutes has passed legislation requiring that to be enforceable, all rules must be in CC&Rs. If HOA bypasses them and passes resolutions or rules and regulations in its place, why do we have to prove they are not in order?
That's the nature of our legal system. It's an adversary process. So if you believe that the rules and regulations are in violation, if you believe that the association has overstepped its bounds by seeking to enforce invalid rules and regulations, as I tell people every day, I can't go put a gun to that person's head and say, do what I tell you to do. That's why we have a court system. As a lawyer, that's the fundamental reason why I became a lawyer, because society, I'm jumping on my soapbox now. Society would fall into disarray without the rule of law. And it's attorneys that help facilitate the rule of law. So to answer that question directly, no, we have a rule of law. We have an adversary system. You can either take that to the Arizona Department of Real Estate, or you can take it to the Superior Court, but you can't just make them do it.
Okay, perfect. And Carolyn had a follow-up on one of her questions a minute ago. To get reimbursed, can I go to small claims court, or where should she go?
So the problem is that what you're seeking is injunctive relief. And I have to be very careful with that term. But you're seeking, So the answer to the question is no, because small claims court can't provide the relief that you are seeking. You're seeking an order of the court to make the association abide by the contract. And also, there's also a jurisdictional money limit. So jurisdiction would not be vested in small claims court for the type of relief that she would be seeking. Now, if she divorced the issues, right? If she simply said, I'm only entitled to $2,500 because of the breach, then she could probably seek that in small claims court, but she's not going to get the other half of that, which would be ordering the association to maintain the exterior of the building. So I guess it's a yes and a no question. Okay. Appeal and enforcement. So again, we talked a lot about enforcement, and I apologize. I'm going quickly so that I leave enough time for questions. But we talked about enforcement. This was my case. And before I litigated this case, there was a donut hole in the law. That's why I don't feel too bad about it. Because the OAH, they can't enforce their rulings. They can't. So it left a situation where if the OAH issued an order and that order could be enforced, well, what good is the order, right? So the Court of Appeals kind of saw that and said, well, yeah, that doesn't make sense. So we're going to allow the Superior Court to enforce those orders, and that's what happened in this particular situation. So if you get an order from the Office of Administrative Hearings and it's not being followed, your next step would be to go to the Court of Appeals and seek contempt. Oh, Superior Court. Yes, I apologize. So before I take questions, I just want to give you a couple of editorials on this. I have changed my mind regarding this whole process. I used to tell my clients, don't go there. If you have an issue with a homeowner, go to Superior Court. Don't go to the Arizona Department of Real Estate. Why? Because you can't get attorney's fees, right? So if you go to a Superior Court to enforce a violation and you win, you're going to get your attorney's fees, right? But as Greg pointed out, and this is the absolute truth, the Arizona Department of Real Estate process is faster, it's cheaper, and it's more what I would call pure. What I mean by that is you get to the truth more quickly. So if you're an association, my client, and you know that it's a violation, it's a cut and dry issue, you may have to spend a little bit of money in the beginning to go to the Department of Real Estate, but you're going to save time, aggravation, and money by resolving it there more quickly. Moreover, if you're an association and you have an iffy case, you have a case where you may be wrong, you want to go to the Arizona Department of Real Estate. Why? Because if you are wrong, you don't have to pay the owner's attorney's fees. So I'll flip that to owners. If you have a strong case against your HOA and you want legal redress, go to the Arizona Department of Real Estate. $500 or $1,000, yes, that's a lot of money, but you're going to get it quickly resolved. And if you're right, you're going to get your money back. If you have an iffy case against your HOA, but you want a judicial review, go to the Arizona Department of Real Estate. Because if it's iffy, you're going to be out your 500, you may be out the other 500, but you got your day in court. And it was quicker, and it's not going to cost you tens of thousands of dollars to go to Superior Court. Now, I have been accused of saying everyone should rush to the Arizona Department of Real Estate. Go flood them with files. No, I'm not saying that. As I said in the very beginning, talk to your board first. Talk to your manager first. Ask for a meeting first. Really try to work these issues out. But if you can't, the Arizona Department of Real Estate and the OAH procedures are great. Do we have questions? If not, I want to give, Greg, do you want to make a closing statement or thoughts? No, I put your lips on.
That's okay. No, it's good to be here. OAH we don't get to have a lot of interaction with the community. We're kind of in our little White Castle up there, so to speak, our White Ivory Tower. But OH is, I'm always happy to come out and talk to any community members. You know, I talk to lawyers about it. I've talked to, I don't think I've talked to per se HOA entities, but homeowners about it before. I talked to some folks out in Mesa about OH and what it does. So I would just say OH is an important part of OH is to help explain to people what we do and why we do it. So we're always happy to come out and do that. And I appreciate the opportunity to come and do this. I was unaware of it, and it's great that Augustus invited me so I could come out here. So that's all I got to say.
Well, we want to thank you for coming out because I know, you know, getting a person of Greg's level on the food chain is very difficult. So we want to appreciate that. So do you have any close? You want to close it up?
Yeah, no, I just wanted to thank everyone for being here tonight. Don't forget, we do have another class coming up this Thursday, effective board meeting. So if you're interested in that, go ahead and sign up for it. Also, as a heads up, Wayne, thank you for pointing out all of the classes that are scheduled to be in person here will also be via Zoom. So they're going to be hybrid. So if you do want to sign up for those via hybrid, you can hop on the City of Scottsdale website, go scottsdaleaz.gov, search neighborhood college, and there's a place to register on there.